Now, the Constitutional Convention. John Adams once described the Constitutional Convention as the greatest single effort of national deliberation that the world had ever seen. And many people today still agree with that. Every state was represented except for Rhode Island, which opposed any major change to the Articles of Confederation, fearing that a stronger national government would injure its lucrative trade. Now, the convention had three basic rules. Voting was to be done by state, with each state, regardless of size or population, having one vote. Proper decorum was to be maintained at all times, and the proceedings were to be strictly secret. Reason for that, if you get a meeting that's letting out little pieces, it gives people enough to start feuding over. As soon as the convention agreed on its rules, Edmund Randolph, on behalf of the Virginia delegation, presented a set of 15 resolutions known as the Virginia Plan, which set aside the Articles of Confederation and created a new national government with separate legislative, executive, and judicial branches. As I said before, they took basically two plans. The Virginia plan was one of them, and another plan, I think it was New Jersey, might be wrong, but they took these two plans, and what was good in them, they kind of put them together and brought those out and added to it. To protect their equal standing, delegates from less popular states rallied around William Paterson's alternative New Jersey plan. That's what I thought. Which would preserve each state's equal vote in a one-house Congress with slightly augmented powers. The Great Compromise for the Connecticut Compromise after Sherman's home state, under which a House of Representatives would be apportioned based on population, and each state would have an equal vote in the Senate. Now, the Constitution begins with the Preamble, or the introductory clause, asserting the authority. We the people. That establishes the document and ordains or orders into effect. This is very different from the opening of the Articles of Confederation, which speaks in the name of individual states and represents an important shift, strongly opposed by some, in the understanding of the constitutional sovereignty underlying the document. The preamble then proclaims the ends or purposes for which the Constitution is formed. In that way, it tells you the history, why they created this document, why this document is important, because they had already lived under these bad rules and these bad laws, and they wanted to create something different. After the preamble, the rest of the Constitution, being a practical document to create a framework of law, describes the powers, procedures, and institutions of government. The Constitution is divided into 7 parts or articles, each dealing with a general subject. Each article is further divided into sections and clauses. The first 3 articles create 3 distinct branches of government: the legislature, the executive, and the judiciary. These three These three branches correspond to the three primary functions of governing: to make laws, to execute and enforce the laws, and to uphold, judge, and adjudicate the rule of those laws by applying them to particular cases. Now, the Constitution creates three branches of government of equal rank in relation to each other. No branch is higher or lower than any other, and no branch controls the other. Each has independent authority and unique powers. The order, legislature, executive, judiciary is important. However, moving from the most to the least democratic, that is, from the most to the least directly chosen by the people, the Constitution lodges the basic power of government in the legislature, not only because it is the branch that most representative of popular opinion, but also because the very essence of governing according to the rule of law is centered on the legitimate authority to make laws. That has you for today. See you again soon.